Well, we are super excited to bring Denise Holliday back with us again today by popular demand. We had so many requests. Denise's first webinar went over so wonderfully that we have invited her back, and today we're going to be talking about the super exciting topic of tenant eviction. And Denise, welcome back.
Well, I'm glad you guys all invited me. It's nice to have a fan base. Thanks.
It is nice. Denise is going to be speaking with us today for about 40-45 minutes, and then we'll be taking questions at the end of today's webinar. So as always, if you'll just type your questions in the question box, we'll be taking the questions at the very end. And so Denise, I'm going to turn it over to you at this time.
Okay, I think we're all here. Modern technology, imagine that. We can all be at our offices, in our home in our pajamas, and still able to come take a class and learn lots of good stuff. Well, thank you guys for inviting me. We're going to learn all about how to evict a tenant today. So this is our first online survey, if you haven't done that before, so I want to know how many of you are property managers? Just get an idea of who's out there. So as many of you know, we are perceived as the slide. We are the mean, nasty landlords who are throwing that poor little sweet thing out into the cold. And we kind of like to have an idea how many of you have been property managers and have an idea of what we're going to be talking about today. So we're still gathering some of that information.
We are gathering some information. So far, about 66% are property managers. 34% look like they're either thinking about it or going into it. I will let you know, Mark, I'm not really sure exactly how many people are on today's webinar. We have a couple of offices of property managers who have 11 people or 20 people who are sitting in. We had over 100 people registered, but if you take into account we have extra 20 or 30, 50 people.
Wow, that's pretty exciting.
I'm not really sure. But it looks like for final we have about 66%.
Okay, well thank you so much. I'm glad to hear that. So evictions, you know, they really are necessary. It's just part of being a property manager, whether we really like that or not. They're a necessary part of our life. What we're going to talk today about is just basically the overview of the important steps and stages that you need to know about, and we're going to generally cover the following topics. Know the type of notices that are given, choosing the proper notice. We'll do that in a minute. We'll watch a scenario. Include the right language. That's imperative, because if you don't include the right language, you can actually have the case thrown out. Follow the correct steps leading into the court. Be aware of some waivers that might happen and the different minefields of that. Understanding the court process, and then completing the actual lockout and resolving the security deposit and avoiding lawsuits to that end. So the various notices that are sent are under the landlord-tenant law, Arizona landlord-tenant law. There are a bunch of different notices that you may issue, and the key is, do you know which one you're supposed to be serving, how to serve it, and then what do you say in the notice? These are the typical breach notices. The number one in a property management world is the 5-day non-pay. It's pretty important that you include very specific language on that one. Typically it's pre-printed, so filling in the right blanks is important. 10-day breach is the run-of-the-mill illegal parking, unauthorized people, a dog barking. If those breaches happen again, then you give a second 10-day, and there's certain circumstances when you can give that and then how it is effective. The fifth one, the next one's a 5-day health and safety. That's basically what I call a 10-day on steroids. So it's the same barking dog, but this dog is now hitting the fence and trying to get out and eat somebody. And the immediate could be what was originally a 10-day made worse, like that dog gets out and bites someone. It could also be other types of crimes. And then the last one is typically a non-renewal. We see a lot of mistakes on how those were given, so we'll spend a few minutes talking about that. So the first one, most common, 5-day non-pay. The person comes in and pays the rent typically on time. If they don't, you issue a 5-day non-pay. It's important that you understand the different language that has to be in there and calculating exactly what they owe. So be specific. How much is owed? Is it January's rent, February's rent? How did you come up with that total? If you do not include that on a 5-day, a lot of judges will look at that and believe that you're not being clear enough for the tenant to know how to fix it. How do the late fees accrue? Your notice should say it's $509 a day times whatever many days. So be specific. Does the late fee include tax? If so, make sure it's listed on the late fee line, and then what's the total, what's the amount per day, is there a grace period, is there a flat fee, and then be specific. How did you calculate those monies? You have the right to refuse a partial payment before we go to court. So send the money back. Don't take it and send them a letter and say it's in my safe, because it's in your safe, which means it's in your possession, and you will not be able to get an eviction because you're still in possession of that money. Send it money back, certified mail, on our website. If you haven't been there before, it's www.drevictor.com. It's all spelled out. So we have a notice of rejection of partial payment that specifically says I can't accept it, and here's the reason why. You can take a partial payment, but only if the tenant signs a partial payment non-waiver form. It says, I will gladly take that money for your promise to pay me the balance on a specific date and time. Make sure the partial payment non-waiver is completely filled out. The mistake we see frequently is you don't include the money that you're taking today, and then yet it needs to be listed on the form. And then also, it needs to say, what does these payments pay them through? Are you including the next month's rent in this or not? The next type of notice is a 10-day non-compliance. These are for typical things like very cute little piggies, unauthorized pets, or unauthorized parking, hopefully not quite that high, but these are typical breach notices that you give all the time. So this is your first test. What notice should you be sending? Hopefully you can watch this video. No sound. Is there sound?
Excuse me, ladies. Does anyone know where we might find Meow of Elle's Toy Barn?
I can help. I'm tour guide Barbie. Please keep your hands, arms, and accessories inside the car and no flash photography. Thank you.
So hopefully the next video we'll be able to have that down. The issue really is, what type of notices would you give for that? So it would be some things like unauthorized people, right? You've got a lot of people at a pool party. It's Barbie, so she would never be breaking the law, but if she was, things like open container, alcohol container laws, or maybe one of your pool rules is she can't have glass out by the pool. If she's hanging out with Ken, she's probably okay, but if she's with G.I. Joe, he's got probably minor consumption of alcohol. Maybe you got some drugs or other things that are happening. So look at, see what's happening. Be specific on, you can list lots of things in the same notice, but you need to list every single thing. An unauthorized pet, pets in the pool, whatever the issue is, be very, very specific about what in fact is listed in this particular breach, and then when did they do it, how did they do that.
So far from our poll, 82% would give a 10-day breach, 23%, the changes while I'm speaking, so 16% say 5-day health and safety.
Could be 5-day health and safety, absolutely. Remember, that's like a 10-day on steroids, so something a little bit worse. So what about the repeated violations? What about when this cute set of dogs has 101 puppies? What do you do about the unauthorized pets, and now those dogs aren't gone, or they have additional pets? That's called the second non-compliance. If they don't fix it in the first 10 days, then you would evict them after that 10-day period. However, if they do fix it, but then later on, now they have, maybe they get these dogs registered and you take a pet deposit, but now they have other pets, that would be the second 10-day non-compliance. 5-day health and safety, that's why we talk about it. It's a regular non-compliance on steroids. One of our evictions. Obviously, this person ate a lot of fast food. This would be a 5-day health and safety, and it technically could be an immediate if there was so much debris that there was nowhere to walk and it was a huge fire risk. When in doubt, take pictures and then talk to your attorney about that. Judges are very concerned about doing an immediate because it changes the time frame so dramatically. So 5-day health and safety would be any regular non-compliance, only worse, on steroids, so that unauthorized pet trying to get out and bite somebody, or the unauthorized car that's parking wrong is now parking in front of a fire extinguisher, that kind of thing. An immediate. An immediate is typically shootings, drugs, prostitution, gang activity. It could be a very scary tenant scaring another resident. It could be that scary tenant calling you and saying, if you evict me for not paying my rent, I'm going to come and hurt you. Or veiled threats. I know where you work. I know what car you drive. I know where your kids go to school. That's an immediate termination. There is no cure period. So when we issue that notice, we issue the eviction simultaneously. We don't give them a chance to move out. Not to say you couldn't, but the law doesn't require you to do that. So let's say, for instance, a tenant starts a fire in the property. And it's not an intentional fire like arson. It's just they weren't paying attention to dinner and it caught the stove on fire. That's grounds for an immediate because it was actual property damage. Some landlords decide, well, they've been good tenants. I don't want to get rid of them. I'll give them a 5-day health and safety and allow them to never do that again. Just be careful. There's some liability if you allow someone to stay when there's been a dangerous thing like their dog bit someone and you say, okay, we'll get rid of the dog, and they say they do but they don't. If that dog bites someone again, now the homeowner's on notice, so is the realtor, and you're going to have liability for not curing that particular issue. Non-renewal. So a non-renewal is, I just don't want to live with you anymore. We've been fine. I don't want to be your landlord anymore. Or the tenant can say, I don't want to be your tenant anymore. I got a better deal down the road. It doesn't matter why you're non-renewing, but a non-renewal, the interesting thing about that, it needs to be given at least 30 days before the final rental period, whatever that date and time is. So this is where we see a lot of mistakes. It has to be 30 days from when the rent is due, the last period. So if you want to evict somebody now or non-renew somebody now, we're already in June. You can't now non-renew them till August 1st. So we're going to do another one. So what notice would you give on this one? So what type of notice would you give? And can you name the movie? How about that? Can you name the movie?
What movie is it?
You don't know what movie? You're not a Disney fan.
I'm a former Disney cast member, and I don't know that movie.
Wow. Yeah. Can't give it away. They're all going to answer right now.
Okay, so what kind of notice would you give your tenant? The 5-day non-pay, the 10-day breach, the 5-day health and safety, immediate or non-renewal? Irene says it's enchanted.
Yay, she wins. If you haven't seen the movie, it makes total fun of all Disney movies, but it's very, very cute.
Okay, I'm going to close the poll. Thank you for that. We have 71% will say 5-day health and safety, 23% say immediate, and 3% say 5-day non-pay.
Okay, so the 5-day health and safety is probably what I would give. Remember, we're talking about non-compliance. That apartment was filthy, so she was cleaning it up, but the fact that she's got unauthorized pets, I will call them, little creatures running around, that would be the 5-day health and safety. You can give a 5-day health and safety if someone is not complying with pest control treatments. If they've caused the pest, you can do it for bed bugs. Basically any breach that is more important than a regular breach that can be cured in 10 days. So think about what is more important, what's the fastest way to get them out, and it is a 5-day health and safety would be your best. It could be an immediate, depending on how afraid you were of mice, I guess. Oops. What am I?
Just hit escape.
Okay, sorry about that. So proper language in the notice. This is where we see a lot of mistakes. It needs to have specific information in each notice. I call it the who, what, when, where, how. Notice, what do they owe? How did you calculate that amount of money? What do they need to do to fix it? And that proper language is what gets you in trouble when you go to court if you haven't clearly said to someone, this is what you need to do. Get rid of the unauthorized dog. Stop parking on the grass, whatever that particular issue is. So what is the specific violation? I love the sign because it really feels that way sometimes to tenants. What am I supposed to do? When did it even happen? I don't even know. You're saying something like wild party. Well, I wasn't here that weekend. Of course you weren't. That's why there was a wild party at your house because you wouldn't be there. So be specific. What did the tenant or their guest do or fail to do? Specificity will get the notice thrown out and you start from scratch. And if you haven't ever been to court and lost, then you don't know. It's a really bad thing because the tenant now believes that they can beat you every time. So be very careful about the language in your notice. So the next step is, what do you do after you issue the notice? That first question is it curable or non-curable? And that's important to understand the difference. A curable notice is the run-of-the-mill breach notices. So pay the rent, get rid of the dog, stop parking there, anything you can fix. Non-curable notices are just that. You can't unshoot somebody. You can't unsell drugs. You can't unlie on your application or your lease. And that's a special kind of irreparable breach notice that we don't see very often, but it's called a 10-day irreparable breach notice, that you lied on your application or your lease. You need evidence that the thing is not fixed. One of the things that happen in my office all the time is the landlord or the realtor will send over the 10-day non-compliance notice. I had that this morning. And I said, okay, well, these other things are not really enough for a 10-day, but this one, they have an unauthorized dog. Is the dog gone? And they typically say, well, I don't know. Well, if you don't know, how do you know they didn't fix it? So that's, remember, part of the curable. Is the dog gone? You can usually tell, go knock on the door. Dog's going to bark. You're going to hear the dog. You don't need them to open the door to know the dog was there. You can hear it yourself. If it's been in a 10-day period, at the end of 10 days, we just file the eviction. If it hasn't been in a 10-day period, you fix it during that time and now it's 2 months later or 3 months later or even a year later, then it's a second non-compliance, and that one is non-curable. Waiver. Waiver is when you act in a manner that makes a tenant believe that you're not going to enforce a right. So the main one is taking money. So let's say you have 2 tenants and the one roommate brings in $500 of the rent. The second roommate's going to bring in the other $500 and they say they're going to bring it in tonight. By taking one portion of the money when all of the money isn't in your office, you've now taken a partial payment. If that second tenant does not come in and does not bring you that additional money, you have lost the right to go evict them this month unless you mail back the money and say it's a partial payment. The problem is most of the time you've given them a receipt. If you gave them a receipt, then you have received the money and you can't send it back. If in fact it's someone at your front desk and they didn't know any better, then you make sure you send the letter saying you were given a receipt, however, we are not accepting those funds. It was that receipt was given in error. We're sorry about that. Here's the amount you owe. Here's the return of your payment. So that's a partial payment, non-waiver, or a promise to pay, they call them too. The one thing that catches a lot of landlords the first time, and it probably won't after that, is what we call a partial performance without a non-waiver. That is when you give a tenant, say, a 10-day non-compliance for unauthorized pets, and you give it to them, say, on the 25th of the month. On the first of the month, they come in and pay their rent, and you accept the rent because you're not thinking about they've partially performed under the lease. Their partial performance was you gave them a notice about the dog, but you don't know if the dog's gone yet. So you cannot allow them to pay the rent, or you waive your right to now evict them for the dog. That's called a partial performance. Could be for just about anything. We also see it, well, they came and paid me the rent for May on June 1st. Well, you took money on June 1st in this month when you knew it wasn't the full amount of money owed. Therefore, you've waived your right to now evict them in the month of June for the June's rent. You don't lose it forever, but you're going to have to issue a notice, not accept any money, and you can't file the eviction until the first day of the following month. So pay attention to those partial payments, but also the partial performance. If you give out a notice, let your staff know, don't accept any money. If you're doing an online payment system, you need to have something that blocks their ability to pay while they're still under that 10-day notice. Going to court, my favorite part, of course, because I'm the attorney. I think that's a lot of fun. I call that my slaying of the dragon. When we go to court, there are multiple steps, and the most important step, of course, is filing the case properly. So, have you been to court before to do an eviction? Let's take a real quick poll. Hopefully this would not include if you were the tenant being evicted. I'm talking specifically about you as a property manager or as a landlord. How many of you have been to court to do an eviction action?
Okay, we're going to close in just a moment. We've got about 75% that have voted. So I'll give them a couple of seconds. As a property manager, yes. Okay, well, thank you very much. So, totals, 54% yes, 46% no.
And the 46% are saying, woohoo, I'm glad I've never been before. But if you're doing property management, eventually you will. It's like a fair housing complaint. If you do it long enough, 10 to 20 years, you're going to get one. That's just part of how it works. So this is our first, what an eviction is supposed to look like, video.
No food for babies, no fuel for fire. Come in.
I come to collect rent,
But I can't pay it.
but you must pay rent.
How to give my door? But I have no money.
Well, maybe we can make arrangements. What do you say, Toots?
So cruel. Hey, oh, woe is me.
I'll pay the rent. Curse is spoiled again.
Well, of course we don't act like that. For some reason, society thinks that we don't want the rent money. Clearly, we want rent money because if we don't have rent money, then we have to evict. That costs money. We have to turn the unit. That costs money. It's going to sit empty for a while. Well, that costs money. So why wouldn't we want the rent? We love the little Dudley Do-Rights of the world, whoever they are that come in and pay somebody's rent, because that's, of course, the most important part. So here's the anatomy of a residential eviction. This is the basics of what the parts are and what they do. The first part is the summons and complaint. They are two separate forms now. If you want to file the eviction on your own, the court has those online. We're in the process of, there's a separate committee from the Supreme Court that I'm sitting on where we're working on updating those forms and making them a little more user-friendly so that people have better access to the legal process. The next step is called the service of the notice versus service of the eviction paperwork. The summons and complaint, two separate forms that tell the tenant you got to come to court, and then when you get there, what is the landlord asking for? That is the eviction paperwork. That's the actual, what we used to call a forcible entry and detainer. The service of the notice is not exactly the same. If you know anything about serving a notice, you know that you have to put it in someone's hand, or you have to send it certified mail, and you have to wait 5 days before it's deemed delivered. The service of the eviction paperwork is kind of the same. It has to be put in someone's hand or posted on the door and mailed certified mail. But in that process, there's only a 3-day waiting period. So the summons is guided by these 3 separate sets of laws. The Arizona Residential Landlord Tenant Act, I have that spelled wrong, sorry about that, the ARLTA, that is the Bible for landlord-tenant cases. The statute specifically is 33-13-77. It says what has to be in the summons and what you have to tell them, where to go. You have to give them the court's phone number. You have to tell them that they have the ability to have an interpreter or to have some kind of disability arrangements made under the ADA. And then the RPEA, which is the Rules of Procedure for Eviction Actions, those are rules that explain the Landlord-Tenant Act and what those new rules do. They help guide us in the actual eviction process and explain in layman's terms what those laws or statutes mean. The complaint is defined by that statute, 33-13-77. It tells us what has to generally be in the complaint. Then the RPEA specifically gives more information and explains who the parties are, what should be requested. It has some special information that the tenant has the right to cure or fix the non-payment of rent before the judge issues a judgment. Those are all statutory requirements that kind of walk through what has to be in the complaint. In 2009, they created a new notice that has to be attached to the complaint, a separate piece of paper, and it is an REIS notice. It's basically a mini Miranda. If you haven't seen one before, it says you have the right to come to court, you have the right to fight this, and you have the right to pay the landlord money in full beforehand. You also have to attach a copy of whatever notice is bringing you to court. So that 5-day non-pay, the 10-day non-compliance, or even the non-renewal notice and the tenant stays afterwards. That would be the notice that we attach. So the tenant knows what was previously delivered to them. The next step is we actually go to the initial hearing. In that hearing, the first thing the judge does is they make sure that the proper parties are there. I can't tell you the number of times that I'm in court that I actually see a realtor who actually has filed an eviction on behalf of an owner. In that case, it must be dismissed unless you're lucky enough to be there and have an attorney nearby that can potentially bail you out of trouble. You do not have the right to file on behalf of an owner if you're the realtor. Even if you have a power of attorney, a power of attorney does not give you the right to legally go to court. It gives you the right to hire an attorney to go to court. So the owner of the premises is the person who has to be present, or the lawyer. A tenant who's in possession at the time they get served. If a tenant has moved out before you start to file the eviction, then you don't have the right to have an eviction action. An eviction action is just that, to physically evict the person from the property. So if they've moved out already, you're going to have to file a lawsuit as a small claims or regular civil suit. However, if the tenant moves out after they're served, which sometimes they do, the process server comes and serves them and they move out before the court date, do not dismiss the case. That's a kind of rookie mistake, because you're entitled to money. And the only way you're going to get a judgment for money very, very quickly, this happens in about 5 days, is this kind of lawsuit. Otherwise, you have to go to a small claims case or a civil case. That can take 6 months to a year. Why do we care? Because we can garnish a tenant's wages with this judgment. So if the tenant moves out after you filed but before court, do not dismiss the case, leave it in place, and still get a judgment. There's kind of a trick. You don't have to get a writ of restitution, which we'll talk about in a second, but you would still need to get a copy of the judgment. Tenants actually have legal defenses. The first legal defense we typically see in court is the tenant says, well, the landlord wouldn't fix XYZ, and therefore I didn't pay them the rent. That's called rent strike. That is not allowed in the state of Arizona. Lots of other states allow it, by the way. So lots of tenants come in and say, I didn't pay the rent because the landlord didn't fix something. If the tenant has given you a notice and claimed there's a habitability issue that says I can't live there because there's no air conditioning and it's 110 degrees, or I can't live there because there was a fire and it burned completely, the tenant has to give you a notice and tell you that you have to fix it in that period of time, 5-day, 10-day, whatever that notice period is. They have the right to give you the same type of notice we give them, a 10-day noncompliance, a 5-day health and safety. The only difference is the tenant has the right to do what we call the choice of remedy. They can either go hire a licensed bonded contractor, and there's some specific guidelines to that, and then take it out of the next month's rent, or they can move, but they still have to wait that period of time for the landlord to cure whatever the problem is. And then at the end of that, their remedy is either to move, which means they can sue you for their moving costs or any increased rent they have to pay or whatever their other costs are, or they can hire a licensed bonded contractor. Remember, that's specific in a statute, so tell everybody who's going to help a tenant with that, make sure you read the statute. It's a little complicated, and there's some restrictions about how much the damages or repairs can be, and then whether or not they can fix something, because there's a specific law that says they can't fix air conditioning. The next step is we go to trial. It's just like what you watch on TV, only not quite as dramatic. There's an opening statement. I stand up and tell the judge why we're here, what the landlord claims is wrong. The tenant has the right to give their opening statement, and then we go right into trial. I put on my case in chief because I'm the plaintiff. I always represent landlords. I tell them why we're here. I put on the landlord or the property manager who explains the lease, explains whatever the notice was and what evidence they have. The other side gets to cross-examine them, ask you questions about who, what, when, where, how. Then I get to ask the questions again, or you would as the landlord. Then the tenant defendant puts on their case. The tenant can say why they didn't pay the rent, or whatever proof they have they did pay it, or that they didn't have an unauthorized dog, or that they have a counterclaim. Then they would put on their case. The interesting thing in Arizona is we don't have regular counterclaims in an eviction action. There can't be a tort. I fell and broke my leg and I couldn't go to work is not a legal defense to the non-payment of rent. That's a separate kind of case. It takes about 2 years to litigate, and so those types of cases are just not allowed in an eviction. An eviction is going to be in court in about a week, and your hearing is going to last between 15 minutes and maybe a couple of hours. Whatever their counterclaim is must arise out of the lease. It must be something that was contained in the lease or the Landlord-Tenant Act. And by the way, if any of you are doing mobile home parks, there's a separate law that does not allow any counterclaims whatsoever. After the judge hears all the evidence, they bring all the evidence in, we do closing arguments, and the court rules, and hopefully that means you win. When you're doing an eviction trial, the one thing you can do that can hurt your case, even if all your paperwork is in order, is how you are perceived by the judge. If they think you're disrespectful, if they think you're argumentative, if he thinks you're not prepared, if you've given five-day notices and each of them have a different amount and you can't explain why they had different amounts, then you can lose a case because the court believes you haven't met your burden of proof.
You want answers? I think I'm entitled. You want answers? I want the truth. You can't handle the truth. You want answers? I think I'm entitled. You want answers? I want the truth. You can't handle the truth.
Well, we did it twice just for extra measure. Okay, so the reason why I show that is be careful. You can say something in a disrespectful tone, or you can go, huh, or tap the table, where the judge thinks now you're trying to hide something, and you don't want the judge to hear the other side's story. And based on your own words out of your own mouth, you can actually lose your own case, where you would have normally otherwise won. So be really careful how you're perceived in the words that you use when you're in fact talking to the court or talking to the other side. In an eviction action, the winner gets the attorney's fees. So make sure that you're careful. If a tenant's trying to settle with you, make sure you're talking to an attorney to see whether or not you are on firm ground. If you're not, you will not only lose your case, but you're now going to have to pay their attorney fees. Jury trial. This is one of the scariest things that can happen in an eviction case, because normally, like I said, our trial is, what, 15 minutes long? 2 hours? I've had jury trials for an eviction. It will take us about 3 weeks just to impanel a jury. It can take us about 2 days to have a jury trial. So what would have been maybe a $150 attorney fee, or maybe even up to a $500 attorney fee, went to $10,000 because of the amount of money that is spent in a jury trial. And typically landlords win, but that's not the point. You've now made your client spend a lot of money. And this is not only just evictions, but civil cases. So here we're doing a quick survey. How many of you have a jury trial waiver in your lease?
And Denise, maybe while they're doing the survey, why would someone need a jury trial?
Arizona law says you have the right to have a jury if someone has alleged that you've done something wrong. So that means in a criminal case and in a civil case. It's an automatic right. With that comes a huge responsibility. I don't see a ton of them in eviction actions, but I see a lot in the civil case where the tenant's suing you for their security deposit, and where that would have been maybe $1,000 or even a couple $1,000, you're now looking at between $10,000 and $20,000 because it now lost so long. And also juries don't always agree and follow the law. If you have an AAR lease, you need to know there is no jury trial waiver in the AAR lease. You absolutely need to add one. So let's see. Is our poll closed?
Almost. Can you repeat that part about the AAR?
Yes, the AAR lease does not have a jury trial waiver written into that. There's been a lot of discussions about that. The group that puts together that form believes that it's too much in favor of a landlord, and I tell them, are you crazy? The tenant's the one who 99% of the time loses, and now they're not going to pay $1,000 in attorney fees if it's a civil case. They're going to pay $20,000. And I've had quite a few owners who are looking at the realtor client, the realtor property manager, and saying, I spent all this money because you didn't have a jury trial waiver, and I think you didn't meet your standard of care. Now, luckily, They lose that argument because they want to file an E&O complaint against you. They lose it because AAR is the agency or the group that puts out the forms, which is basically the standard industry, or the industry standard. If it's not in there, then you're going to be okay. So how many of you have a jury trial waiver?
Okay, well, about 50%, excuse me, of our attendees today voted. 48% say yes, and 52% said no.
Okay, you're going to fix that on every single lease that you now do, because that is a huge, huge liability issue. If you don't know what language to put on there, we have a remedy for that. You don't have to use us. Our website is free. Just go to what we call suggested phrases and clauses and look at ours and wonder why you might want to use some of those. And jury trial waiver is the most important one out there. The next stage is the writ of restitution. It typically happens at 5 days after court. Unless it's an immediate, that's 12 to 24 hours after court. That's where the constable comes and removes the tenant from the premises. That date is not discretionary from the court, but you can give up to 45 days to do that lockout. Be careful. Make sure you explain why you're giving that amount of time in writing, or the judge can say you've reinstated the lease and you can lose your right to get the lockout. So the question is, who provides the locks? You do, by the way. It is not the court's responsibility. It is your job to have a locksmith there, or have gone down to Lowe's or Home Depot and have a new set of locks. If you don't change the locks, the tenant can come right back in after that big orange sign's been placed on the door, and it's been your responsibility. We're going to skip the survey real quick since we're running a little bit out of time. If that tenant refuses to leave or stays without your permission or comes back without your permission, call the police. That is criminal. That is called a criminal trespass. They should come and arrest the person immediately. The last section is the things that I see happen the most that are wrong. Once the tenant is locked out, you are required to let them come back one time, and there's some specific things they're allowed to get out automatically. I tell you, let them take whatever they want. I hate moving myself. I certainly don't want to move somebody else's junk. You can turn off the utilities the day after the lockout, but not before. If you do, that's an automatic violation. You owe them 1 month's free rent, minimally. If the tenant gets locked out, they have the right to get their stuff. After a writ of restitution, there's certain things they can get without paying you anything. They're the kinds of things that you would think of, like their passport, their medicine, banking records, those kind of things. The rest of those things, anything else like the couch, they have to pay you the cost to store it or move it if you've moved it. That gets a little complicated if you're going to leave it on the premises. Basically, it's the daily rental rate. So you rent divided by 30. The daily rental rate is the amount of the storage fee that they have to pay before they can move it. You must send them this 21-day form. If you do not send the form, then you have lost your right to charge them anything. That form is on our website. Again, it's a standard 21-day form. It reminds you of all the statute, what you're required to do, what they're allowed to take out. What about pets left behind? I always laugh because I go, you took your kids, why didn't you take your dog? But all the time pets are left behind. The sad answer is you're required to store the dog for 21 days. Really? Yes, it's a stupid law, which means you may have to pay to have it boarded, especially if an in-house, a dog that lives inside can't be put suddenly in the backyard, especially when it's 110 degrees outside. And so you would have to pay to have the dog boarded. You could have anyone do that, but I would suggest that you use somebody who's licensed and bonded, and they have to store the pet for 21 days. Be careful about disposing in any of those items before the 21 days, and by it's 10 days, by the way, if it's an abandonment. There are specific forms you must send out, the 21-day form or the location of abandoned property, which is the 10-day form. Those must be sent certified mail, return receipt requested, to the address which they left and any alternative addresses that you know. Huge mistake made by a lot of people. Now, if the tenant skips out and they abandon things, or they give you the keys and they leave something in the garage or the attic, you can actually throw those things away without storing them or sell it without storing them, only if your lease has magic language. The AAR lease does not include this magic language. So if you want to have this special clause, once again, it's on our suggested phrases and clauses on our website. It basically says if the landlord reasonably determines that the value of the stuff is left behind is so low that the cost to move it and sell it is less than what it's worth, we can toss it immediately. That is not the law for writ of restitution. That is only the law for an abandonment. An abandonment is when it's, or if they leave stuff behind and they've returned the keys. The last one is security deposits. You must account for the security deposit even when you've evicted them. The law says you're required to do that with them within 14 business days. And if you're storing this stuff for 21 days, those deadlines run simultaneously. So you must tell them, I don't know what I'm going to take out of your security deposit other than the judgment because your stuff is still in the house. And I don't know if there's stains on the floor. So now we have some time for questions. Anybody have any questions?
We do. We have quite a few questions. So thank you very much, everyone. And Denise, thank you as always. You did a great job. All right, question number 1. This is a good question. How much communication should happen after the notice has been issued? For example, a 5-day non-pay via certified mail. Do you recommend not speaking to the tenant via phone, discuss procedures, circumstances?
That's a business decision, not a legal decision. And so everybody has kind of their own rule. I can tell you that I like conversation, especially if you're documenting it, because it's clear that you told them that they owe rent, you gave them the chance to fix it. When they come to court and say, Judge, I never got that 5-day notice, we don't care because you sent it certified mail, so it's deemed received by you. After 5 days, if they sent you an email that says, hey, I got the 5-day, I promised to pay you Tuesday, that's terrific. You can now not wait the 5 days for mailing, just wait the 5 days for them to pay, because now you have proof that they actually got the email or got the notice. Email proof is wonderful.
On your screen, folks, is all Denise's contact information, and her website is right there. We had several requests for Denise's website. It is Dr. Evictor, all spelled out, .com, and there's her phone number. All right. The next question up is, can you have a house sitter for the animals that are left behind that you need to take care of? Can you hire a house sitter? Does it need to be licensed, bonded? What's your recommendation?
I would not have a house sitter in that house because their stuff is still there. And now you have the risk that someone's going to steal those items. You can have your neighbor, you can take them home yourself. It doesn't have to be licensed and bonded. The fear that we have is, what if the animal gets sick? What if the animal runs out the front door? What if the animal bites someone? Because it's afraid. You know, they don't know where their mommy and daddy is either. And so our furry little friends can act inappropriately sometimes when someone else is watching them. That's why I suggest that you have a great relationship with maybe a no-kill shelter, because they'll board that animal for you and then put the dog up for adoption if the tenant doesn't come in and pay that boarding fee. Or if you know another agency, the rescue societies are really running out of space, and so you need to get a little more creative. The local agencies are not able to take any more dogs or cats, and they're just not able to help us anymore. So you need to think of something like even a vet, and then pay for that cost. Remember, your owner's paying for that, and it could be $30 a day. So be careful what you're spending, but be responsible. Don't allow the animal's health to be in jeopardy because you have the right to turn off the utilities and do nothing for 21 days.
A lot of questions about those those animals not taken with them.
Yeah, I can tell you, we strongly suggest that you take out the application and you call every single person you can, including their employers, to tell somebody, look, we have this dog or the cat, it's been left behind. We have no choice but to send it to a boarding facility, and you'll never see the animal again unless you pay that cost. Really encourage them to come and get that animal, because that's a huge problem. We tried to get the law changed, and they wouldn't allow that.
Does it matter what kind of animal it is? If they left a bird in a bird cage or a snake, I mean, does it matter what kind of animal?
It doesn't matter. In fact, you even are required to store their plants. We're not sure if you have to actually water them, because the law says you can turn off the utilities, but if you didn't take care of the animal, you could be charged with animal cruelty. And so I can tell you what lots of people do is they contact the sheriff's department and say the animal's been left behind. Just be careful. You're required to store it for 21 days. And Sheriff Joe will probably not do that. They'll come and take the dog, and the person now doesn't have the right to get the dog back. So be careful on what you do with those animals.
Is there information on your website?
There is information on our website on what you do with the animals. We actually have a section that says what I do with my tenant stuff now. and that kind of gives you a better idea about what you need to do.
Okay, that sounds like a great resource. Absolutely. Let's see. What is the legality regarding text communication with a tenant? If, does it serve as proof?
That is a great question. Arizona has an electronic transmission statute. So yes, you can absolutely do communication through electronic methods. I suggest that you add that as a clause. It just says an additional term and phrase that the parties agree we can communicate via email, and list the email addresses actually on this addendum or on those extra lines, and the tenant's cell phone number. And even say if the tenant changes their phone number or their email address, they agree to notify you within, say, 10 days. But absolutely, if you can print off the text or print off the email, then anything that they send and say to you does count as communication. By the way, anything you say to them counts as communication too. So if you're sending them a 10-day noncompliance and you mail it to them and you also email it to them and they respond back, then it's deemed received. By the way, those read receipts do not count as proof that they actually received that. All that is proof that somebody opened it. So you really need to be creative. I have some rental properties, and so what I say is in the little regarding line, cutest puppy ever, and then I say, oh, by the way, the neighbors were saying your puppy was crying. By the way, I didn't know you had a puppy. You need to come in and pay a pet deposit and register the pet with me. Attached is a 10-day notice. I really want to let you keep the dog. Please get a hold of me. That causes the tenant to now respond. Same thing if they haven't paid their rent. Gosh, I don't want to, eviction pending. Attaches a 5-day. I don't want to evict you if you're having some hard times. Please contact me. I really want to work with you. That really entitles you into a faster court date. You can get there as soon as they respond and not wait for any mailing period. But be careful how you write it, because a judge can read that too. And write it in a way that solicits the tenant from responding back to you.
So it's opening up the dialogue.
Yep, absolutely.
Okay, so if a tenant moves out, if a tenant owes money after the security deposit has been credited, how soon do you have to send a letter for the additional repair costs, and does the letter have to be certified?
Great question. So the security deposit law says that within 14 business days after the tenant returns possession and demands some kind of accounting. By the way, most judges ignore that second part. So I just tell everybody count 14 business days, and if you're like me, I'm going to count 14 straight days so I never miss a deadline. You need to do an accounting of their security deposit. You need to tell them you owe me rent for the next 6 months because you're walking away out of your lease. You're going to accelerate that rent. You're going to estimate certain things like those utilities. But any other thing, you need to have some kind of receipt or a pretty good idea of what those damages are going to be in order for you to charge them on the security deposit disposition. You do not have to mail it certified. In fact, the statute says regular mail, but you need to have proof you sent it. So I think certified mail is one of your best proofs. It's $5, or even if you do it registered, it's $3. It's just really good insurance to show it. If you have an email address, send it via email too.
And I know that we go through steps sending the certified mail. What happens if the tenant just flat out refuses to sign the certified letter?
That is a great question. The law pretends like they got it. We have a statute, ARS 331313, that says when somebody sends something certified mail, we pretend like you got it. It's called deemed receipt, whether you pick it up or not, after 5 days. So whether or not they ever pick it up, you just pretend like they got it and then start counting. That's the mailing period for 5 days. And then now count the breach period. When it comes back, which it eventually will, maybe 3 years from now, I joke because we know we never get those certified letters back. But when they do, just toss it in the file and just show that you really sent it.
That is a great question. Okay, so here's a scenario. The dog ran out the front door when the eviction was in process. Who's responsible?
I'm guessing you mean when the constable showed up. You and the constable standing there, the dog ran out the front door. That's just an accident. I would be afraid that the tenant would want to sue you now because they might think you did it intentionally, because some landlords are known to do something very stupid like that. I would still contact the tenant, let them know their dog was out. Take every step you can to catch the animal by just opening the door and letting something out. Yet now you've not taken the steps to protect that animal, and now you might be guilty of what we call dog at large. As you know, I'm a pro tem judge too, and I hear those cases, and that actually, surprisingly, is a felony. It's not a misdemeanor if a dog is at large, especially if the dog bites somebody or injures somebody. So very, very serious. It's a criminal issue. So don't let somebody else's dog get out.
Wow. Wow. Up on your screen, folks, you can see that Denise has 2 property management boot classes coming up, one in July at the Phoenix Association of Realtors and one in September at the Scottsdale Area Association of Realtors. Denise, give us some insight to these great classes.
So if you haven't been, I have to tell you, we've been doing these for about 4 or 5 years. This particular class scares everyone half to death. Everyone who leaves is frightened and wonders, why in the heck am I doing property management? What I like about the class is it's broken up into sections. And the idea of the class is to give you a little bit of information about a lot of topics. So we talk a little bit about fair housing, a little bit about landlord-tenant, a little bit about trust accounting, a little bit about disclosure requirements, a little bit about bookkeeping and records retention. There's enough there for you to figure out, oh, I got that, totally understand that subject, or holy cow, I have no idea what they're talking about. Now you know that's a gap in your education, and you need to take a full 3-hour class on that particular topic. And that's what I really like about it. There's an overview of a lot of subjects. It's a 6-hour class, fabulous class, and it really helps you understand all parts of what you need to know as a property manager.
I know that we have several members who have taken this class 3, 4, 5 times, and every time they walk away with like this aha moment.
That we hear that all the time when they were filling out the surveys afterwards. You know, I've taken it 2 or 3 or 4 times, and I still found something I didn't understand the last time they talked about it. Now I know this is an issue, and I need to go in and fix that. We also give you some great ideas on when you're sitting in a class and you have the, oh my gosh, I'm going to lose my license moment, or I'm going to get sued moment. We tell you, how do you fix it right now before you get audited, before you're in trouble? How do you fix that thing? So we don't just tell you what you're doing wrong. We give you the hints on, here's what you can do as a Band-Aid, and then here's the rest of the tools in your toolbox about how to actually really go in and fix it permanently.
What if, we're going back to the mean attacking dog again.
Okay.
So what if the tenant warns the landlord or property manager that the dog will attack if they enter the house?
We see that a lot on the tenant's advocate notices that say, I want you to come in and fix these items, and by the way, if you come in, my dog or my snake will hurt you. That is basically a threat. They should be able to have that animal contained. But if they tell you this animal is a vicious animal, I would give them a 5-day health and safety and say, thank you for the warning. By the way, it's your job to make sure you don't have a dangerous animal on the property. They typically give that only when they don't want you to come in and make a repair. And you think, why in the world would a tenant give you a repair notice and not want you in? Well, either they're already moving out and they're looking for a fake way of getting out of the lease, or they forget that they're doing something illegal and they ask for the repair and then realize, oh darn, I'm growing marijuana plants, and they might actually see that. Or you'll actually see the unauthorized dog, or the unauthorized occupants, or how filthy the home is. And so sometimes they'll give you a repair request and they didn't really want you to go in. By the way, if you guys don't know, the law changed several years ago. If they give you a repair request in writing, that automatically gives you permission to enter, and no separate access notice is required. You can go in today and fix that issue immediately.
Wow, that's excellent. Now we're going to go up to this one real quick. If you, as a property manager or owner, are not going to renew a lease, and the lease ends the last day of the month, August 31st, are you giving them the 30-day notice as of August 1st or September 1st?
We recommend that you give them that 30-day notice 35 days before their lease expires. Because if you don't hand deliver it to them, it's 5 days from mailing. All things are deemed delivered after 5 days. And if you gave it to them on the 1st and they didn't pick it up, you don't have the ability to non-renew at the end of that month. So we're in June. If you don't want them, if their lease is up at the end of July or they're month-to-month tenant, I give them a notice anytime in June that they need to be out by the end of July.
So the 30 days is more of a guideline. It could be 45 days, 50 days.
Absolutely. The law says at least 30 days. So it could be 35, it could be 40, it could be as much as you want. It can't be 30 days from the day you give the notice. It's 30 days from the final rental period.
Oh, good to know. Good to know. And do you have any repercussions or suggestions of what a property owner can do if the property is just filthy?
If the property is absolutely just filthy, then you give a 10-day noncompliance for not keeping it in a clean and safe condition. And then do another inspection at the end of that 10-day period to see whether or not they've cleaned it. So when you give the 10-day notice, you're probably going to give them a 10-day notice and a 2-day access notice and say, I'm coming in on the 10th day. Because remember, 2-day access notice is at least a 2-day period. So it's a good idea when you're giving them a 10-day cure, give them notice you're coming back in to check on it on a certain time frame too.
Okay. And does that also include like hoarding?
Hoarding, that's a 5-day health and safety, maybe an immediate if it's actually fire hazard.
Okay.
And by the way, pictures are your friends. Take pictures of whatever you see because that's what a judge needs to be able to know about.
Okay. And let's talk about just real briefly. Thank you for your time, Denise. We've
Sure.
got tons of questions.
Oh, I'm here as long as you want to keep me.
Okay, so the property owner wants to list the house for sale almost near the end of the lease, but the tenant has the nasty dog and won't allow the home to be shown.
We tell you that even though you have the right to show it to potential buyers or potential tenants, be super careful. You should not put on a lockbox on an occupied home, especially a tenant-occupied home, and you absolutely cannot include that phrase on your lease either. It's a huge issue. If they're not going to keep it clean and they're not going to have the house ready to be shown, you're losing a potential audience. So if they have that vicious dog, tell the owner, don't show the property till they're out. Because even if they lock up the dog, they're not going to clean up the dog poop, they're not going to clean up the dishes, and whoever's perspective is not going to come back next month to see what it looks like when it's really been cleaned.
Excellent point. We're going to go back to what we were just talking about, the 10-day notice with the 48-hour entrance notice. Are you able just to go ahead and enter the property after that 2-day notice?
That's a good question. The problem with most 2-day notices is that you didn't serve it properly. You go and post it on the door, say I'm coming in 2 days. Well, that's not delivery. Remember, you have to put it in their hands, or you have to mail it certified mail and add 5 days for delivery. So that becomes a 7-day notice. Can you come in when you properly serve the notice and the time frame has expired? Yes. If you get there and they say specifically you cannot come in, give them a notice one more time, and if they still don't let you in, you can evict them. There's a special notice on our website that explains how to do that. But if they've changed the locks, same thing, don't go in. You do not want to breach the peace or you will be arrested. But yes, you can go in unless they specifically prohibit you from doing that. If they prohibit you, you can do an eviction.
Wow, that's incredible. Okay, and then Denise, if you want to just maybe give us some closing thoughts, something that we should all be aware of, an aha moment that we can take to work and share with our other property manager friends today?
I can tell you the big aha moment I have for most people in the industry is that you don't understand that doing an eviction is not just the court. It's all the steps leading up to that. It's like a good marriage. You need to get to know each other first. So know what notice you have. Notice, be the right kind of notice. Use the right kind of language. Serve it the right way. Make sure you haven't waived your right to go to court accidentally, like by accepting the rent money. And then when you come to court, come prepared. I can't tell you the number of times clients go, well, why do I have to go there? I'm like, well, I'm your attorney. I'm not the mouth. I can talk to the judge, but I can't hand them a lease without you explaining what that lease is and identifying that as a legal document. I didn't deliver the notice, you did. And so you can't expect an attorney to go and win in court if you're not there and if you don't have a good file. So preparation before the eviction, preparation for the eviction, and following the law after the eviction will save you every time.
That is great. Well, thank you, everyone, for joining us today. On the screen, you're going to see that AAR provides 3 ways for you to learn more and earn more. We have in-classroom classes available at all of our locations and all of our associations. We have our online webinars like the one you are attending today with Denise Holliday. And we have our remote classes. And these are brand new. We've just rolled them out this year. And if you have the opportunity, please, 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 these are a great way to learn. It's where we take one class and you go to your local association. We're going to bring the class to you via live video remote or live feed. So this is a great way to learn. All of our classes, as you can see, are available on our website at aaronline.com/calendar. And you can see where they say if they're a classroom webinar or a remote availability. Denise, thank you so much for joining us today.
Thank you for having me.
And folks, again, you'll be receiving a follow-up survey in about 2 hours. Let us know what you thought of Denise's presentation today. And if you have any questions, I'll pass them along to her. If you have any recommendations for future webinars, please let me know. We're always open to those. And as always, all of our webinars are recorded and available online on our website at aaronline.com. Thank you very much for joining us today.